Greetings from Toronto. A warm welcome to all of you joining us today from Canada, Nigeria, and beyond. My name is Dr. Uche Ungwaba. I am an assistant professor at the Lincoln Alexander School of Law at Toronto Metropolitan University. Today, we are so pleased to bring together key experts from the legal profession for a webinar to explore the future of Nigeria's justice system. The law school is proud to host this special event in collaboration with Marsfield LP, a future-focused law practice with offices in Nigeria, Canada, and South Korea. Over the next 2 hours, we will host 2 dynamic conversations where we will take a deeper dive into various themes related to Nigeria's judiciary, including efficiency, autonomy, governance, funding, technology, legal training and education, and most importantly, access to justice. I would like to mention that live captioning of this event is available for participants and it's embedded within Zoom. We will also post a link in the chat for easy access. Before we officially begin, it is important that we recognize the land on which the Lincoln Alexander School of Law operates. Toronto is in the dish with one spoon territory. The dish with one spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent indigenous nations and peoples, European settlers, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. Today, this meeting place is still home to many indigenous peoples, and we are grateful to have the opportunity to work on this land. Thank you. As many of you know, Nigeria's justice system has witnessed its fair share of some of the instability that has faced Nigeria as a country over the years. In this sense, the administration of justice is challenged by inefficiencies that impact access to justice for litigants on the one hand, and a crisis of governance involving operators of the justice system on the other. In responding to these issues, we've put together 2 back-to-back panel discussions to explore 2 sub-themes: efficiency and access to justice, this panel, and immediately following, operators of the justice system. Both panel discussions will include a short segment for audience question and answer. We encourage you to submit your questions at any point using the Q&A feature on Zoom. We may not have the time to answer all of your questions, but we will do our best. I will now invite my distinguished lineup of panelists to join me for the panel discussions, inviting them in alphabetical order. I'll first like to invite Mrs. Laura Alakija. Mrs. Alakija is the managing partner of Primera Africa Legal, a top commercial law firm in Nigeria. I would also like to invite the Honorable Dr. Chili Ebo Osuji. Dr. Ebo Osuji is distinguished international jurist and special advisor to the President's Office. He recently completed his term as president of the International Criminal Court. The third panelist I'll be inviting is learned senior advocate of Nigeria, Chief Anthony Ikemefuna Idigbe. Chief Idigbe holds a doctorate degree from Osgood Hall Law School and is the senior partner at Punuka Attorneys and Solicitors. Finally, I would like to invite Ms. Osai Ojigo. Ms. Ojigo is currently the country director of Amnesty International Nigeria. She is also a civil society leader with extensive experience working in the African human rights system. A warm welcome to all my panelists. In moderating this panel, I will give each panelist 5 minutes to make their opening intervention, after which we will engage in an interactive discussion where I will be posing questions to our panelists including questions that have been submitted by members of the audience. I would now like to invite Chief Idigbe for his opening intervention.
Thank you very much, Uche. It's a pleasure to be here. Let me just talk about the social contract theory, which postulates a limited role for government in the protection of life and property. Thomas Hobbes argues that the social contract involves the people exchanging their agency for violence in return for protection by the government. One of those government obligations is justice delivery. In classic Leviathan and Hobbesian theories, the monarch exercises supreme authority via the social contract, including delivering justice directly or through advisors, now the courts. Montesquieu observed that such absolute power corrupts and suggested separation of powers with checks and balances. Judicial independence concepts seek further to insulate the judiciary from other arms of government, thereby ensuring more effective protection for the people. I examined the history of court governance in Nigeria in stages of colonial, post-colonial, military rule, the federal structure, and transition to civil rule. During the colonial era, judges were appointed by the colonial government. The common law governance system was imposed with amendments to suit the colonial agenda. For instance, strict separation of powers was not always practiced during colonial regime. Also, a local legal profession was not encouraged. Lawyers had to qualify in the UK, and a law school was only established post-independence. The regulation of the profession was held tightly by the colonial government through control of institutions like the General Council of Bar, a situation that remains to date. Now, as independence approached, the government opened the appointment of judges to the indigenous lawyers, choosing the best who were willing to take up the appointment. Further, the emoluments were competitive and tenure secure. Now, civilian rule was unfortunately interrupted by military intervention in 1966. The executive and legislative arms of government were abolished. Only the judiciary survived, but was bruised and ignored by the military, including by the passage of a decree declaring that it was supreme and not subject to the authority of the court. The military engaged in various experiments of political structure and return to civil rule, including the abolition of regions, creation of states, and two-level civilian and military governments. Eventually, the civilian government stabilized after several stumbles. Political contestation was vicious even among the civilian parties. The perception of abuse of checks and balances and lack of financial and political independence or security of tenure, which climaxed during military government, persisted during the early stages of civilian rule. There was an inability to attract the best talents from the profession. The Justice Kayode Esho panel was instituted to investigate the causes of the decline in the judiciary and recommend solutions. A key recommendation was the centralization of the appointment and discipline process. The Esho panel also recommended the creation of a National Judicial Council to recommend all appointments at both federal and state levels, as well as discipline of judges. The composition of the council was to insulate it and the judges from interference from the executive arm of government. Unfortunately, the NJC and a sister institution, the Federal Judicial Service Commission, became an albatross in the governance of the courts. The composition of the NJC enthroned absolute separation of power. It had an all-judiciary membership. The Chief Justice of Nigeria chairs it, and practically every other important judicial institution, and appoints all non-judiciary members. Yet the NJC is situated in the executive chapter of the Constitution. The inclusion of the NJC in the Constitution as a super institution means no ability to amend or restructure it. Consequently, there is a constant resort to unconventional means of intervention by the executive, such as raid of the courts or the judges, use of code of conduct, and even recently, the judiciary itself had to use unconventional means to get out the CJN. Another weakness in the governance structure is the multiplicity of regulators and the existence of regulatory capture. I refer to the 2017 report of the MBA committee, the Legal Profession Regulatory Review Committee. Further, there is inconsistent jurisprudence on judicial governance. For instance, in Nganjiwa against FRN, it was held that only the NJC can deal with corruption charges, and a judge in active service cannot be investigated or tried in a court of law unless such a judge is first removed from the bench. But contra the case of Onedian, where a former CJN was tried before the Code of Conduct Tribunal while he was in office. So some of the consequences of the weaknesses in the governance structure include nepotism, cultism, corruption, promotion mentality within the judiciary, exclusion of career commingling at the top echelon of the judiciary, inability and lack of willingness to attract the best to the judiciary consistently, poor management of the justice delivery system, delay in justice delivery, decline in quality of judgments and justice obtainable, increase in resort to self-help by the citizens, rise of non-state supported alternative justice systems such as OPC, Bakassi Boys, herdsmen, etc., breakdown of rule of law, and prevalence of impunity. Now, are there remedial tools available for rescuing the judiciary and guaranteeing the future of the institution? I think there are, but it may involve constitutional amendment. It may also involve the implementation of the MBA recommendations and the draft bill for reform of the legal profession. And it may require immediate government action to protect the welfare of the people by stemming the tide towards impunity and breakdown of rule of law through massive financial and administrative intervention in the judiciary, the type we saw in Singapore or Kenya. Now, are there impediments to implementation of reform? Yes, there are entrenched interests, there's legal constraint, there's lack of leadership and vision. In concluding, I would say that because the governance structure has a correlationship with the people that will be attracted to the judiciary and their level of accountability and the output of the justice delivery system, and these have an impact on the overriding objective of enthroning the rule of law rather than the survival of the fittest, there is a need for a mindset change among the various arms of government and a realization that justice delivery is a social good that should be cooperatively delivered by them whilst respecting judicial independence. I think that the judiciary must self-innovate and transform itself to remain relevant in Nigeria. Thank you.
Thank you very much for this very deep history about the judiciary in Nigeria. I will now turn to you, the Honorable Chile Ebo Osuji, for your opening intervention. Could you unmute yourself, please?
Thank you very much, Professor Ngoba. It's an honor to be amongst this distinguished panel. I will take it from that philosophical and historical perspectives that Chief Idebe gave and bring it home to a certain brass tacks. And I come at it from this perspective. As you know, I practiced law in Nigeria, in Canada, and also on the international stage before sitting as a judge and the ICC. And then from that perspective, I come at this discussion. The panel here is efficiency and access to justice panel. And when we talk about access to justice, we are, of course, talking about the people's access to justice and what justice means for the people. Chief Idebe has given us some very important historical background and philosophical premise from the Hobbesian theory to Montesquieu. Now, there's one, in terms of meat and potatoes, appreciation of what justice does for the people, and especially from the perspective of the focus I want to give, which is proper funding of the judiciary, including proper adequate remuneration of judges in terms of salary and pension. Let me bring in the views of somebody everybody knows about, Adam Smith, the father of the theory of political economy. He wrote that book in 1776 entitled The Wealth of Nations for short. In it, he examined the different factors that contribute to the economy of a nation. He gave different, factors, but then he comes down to this. He said, above all, he said, there's nothing that gives greater encouragement and most effectual encouragement to all sorts of industry, and remember here, all sorts of industry, than the administration of justice. It brings it in. So whatever you do, after all said and done, there's nothing that gives the greatest encouragement and most effectual encouragement to administration of to the economy, to all sorts of industry, than the administration of justice. And he continued to say that it is for that reason that proper funding of the administration of justice is something that must be done for the benefit of society as a whole. And I would again move it to the access of people to justice. The proper funding of the judiciary requires judges to be paid adequately and that pensions secured adequately. It is for the good of the people that this must be done. Why? The Canadian Supreme Court answered that question in 1997 in a case called Reference Remuneration of Judges of Prince Edward Island. In that case, the court situated the idea of proper or adequate remuneration and pension of judges as a constitutional question. And that is Section 11D of the Canadian Charter of Rights and Freedoms that guarantees persons accused of crimes to a fair hearing before a court that is independent and impartial. The emphasis there is independent and impartial. So it was seen as a constitutional matter for judges to be remunerated well. Now you move from there, of course, that authority I recommend is persuasive authority for the Nigerian legal system. The parallel to Section 11D of the Canadian Constitution or Canadian Charter of Rights and Freedom is what? Section 36(1) of the Nigerian Constitution, in fact, makes that similar provision in a more robust and direct way. The Canadian version situates it in the context of a criminal trial, but the Nigerian Constitution, Article 36(1), actually talks about in any suit before a court or a tribunal, the persons or Nigerians have a right to a fair trial before a court or tribunal that is that must be independent and impartial. So whenever you see the concept of independent or requirement of independent and impartial a tribunal, therein you look for the independent judiciary, the right to judicial independence, and a critical factor in the judicial independence of a system is actually economic security of the judges, economic security so as to protect them from the vulnerabilities that they're exposed to when salaries and pensions are inadequate. So that is why you look at it, and this is consistent with international standards. There are different instruments that speak to that. UN Basic Principles on Independence of Judiciary, a Universal Declaration of the Independence of Judges, we call that the Montreal Declaration of 1983, the International Bar Association Minimum Standards of Judicial Independence, that is Clause 14, Commonwealth Latimer House Principles that also speak to this. You speak about the Commonwealth Compendium of Best Practices. You look at pages 73 to 78 of that instrument, Uchenna, is my
Yes.
time up? All
Yes.
right. So I'll leave it there, and then I'll probably say more during question time. I must respect your time. Thank you.
Thank you very much. Thank you very much. I will now invite Ms. Alakija for your intervention.
Right. Thank you very much, Uche. And I am delighted and relieved to be speaking after Chief DBSAN and Chief Ebo Suji as well, because they have pretty much laid a good foundation that I can build on. And I'll be speaking from the perspective of the application or the use of technology in the justice delivery system in Nigeria. And to sort of put things in perspective, I will tell a few personal stories to sort of clarify my intervention. I remember when I got admission to study law at the University of Jos, one of the first things that the Law Student Society at the time did was to try to introduce first-year students to the justice system. So they took us to the correctional facilities and to the High Court. And when we got to the High Court, they had structured it such that we met a trial in progress and counsel was cross-examining a witness. And I remember, walking in very excited and thinking I'm about to experience a Matlock moment. But I found very quickly that, the counsel would ask his question, then the witness will say one line, and then counsel will ask him to hold on. And then he would wait a moment and then say another line, and counsel would. So I whispered to the senior sitting beside me, what's going on? Why can't he just answer the question? And the senior said to me that, oh, the judge has to write everything longhand. So we have to wait for the judge to sort of catch up with the witness testimony in order to be able to conclude his record of proceedings. Fast forward a few years later, when I joined the labor market, my first job was in the legal services sector, working for a publishing house. And at the time, I was working at the electronic and digital resources department. So at the time, what we were doing was essentially deploying digital legal resources to institutions, courts, and law firms. So sort of across the whole legal services sector. And, at each point in time, we had to train students or lecturers for institutions, judges in the courts. And when we went to law firms to train legal practitioners, just sort of introduce electronic technology in general to the legal services sector. And some of the pilot projects we tried to do at the time was, apart from establishing digital libraries in those places, was digitalizing the records of the Court of Appeal at the time. And I remember that we had to take all the physical records of a court. If you know how the physical records are stored, you know that they're typed and then they're pasted in this booklet and they're stored according to each case. And so the first thing we had to do is to get high-speed scanners that would scan those judgments about 100 pages per minute, then train staff of the courts how to use those scanners, how to scan the material, then convert them to documents that you could then upload to a digital database that we had created for the courts so that it will make it easy to retrieve the cases. Once that was done, then we had to train the judges and the legal officers and their legal assistants or research assistants, to use that. And we sort of uploaded that data and the courts began to use it. And I thought that with that intervention that, most other courts in Nigeria would sort of follow suit and it would just, be a wave of technology sweeping across the whole nation. I'm not excited to say that hasn't quite happened yet, but, the process is ongoing. But my point is, in terms of justice delivery, we've looked at the historical perspective and we've seen the interventions that the government should make. We've also seen, we've also had some conversation about what the legal framework should be. And my intervention is, in order to facilitate justice delivery in Nigeria, some of the other things we need to look at are 1, infrastructure, and 2, manpower. And, those are the 2 areas where we still have a lot of gaps. 3 weeks ago, somebody called me with an SOS to on behalf of someone who had been convicted of murder and sentenced to death by hanging. And after a lot of back and forth, my firm decided to take up that case pro bono. And so we sent a lawyer to that state to sort of get the records of proceedings and file the notice of appeal. And up until the date when we were ready to sort of reconcile records so that we will proceed with the appeal in that matter, the records of proceedings were not ready because they were still typing out what the judge had sort of put down longhand. So the records of proceedings were not ready, even though everything else was available and we were ready to proceed with the appeals. So to that extent, you can see that we still have gaps in terms of technology, in terms of the infrastructure, obviously, even in terms of the legal framework. I think the pandemic sort of showed that very clearly when the pandemic hit. At the time, there were a lot of arguments back and forth about whether Nigeria could constitutionally, whether we could hold virtual hearings or not. So the CJN immediately set up, the CJN at the time, yes, immediately set up, virtual hearing facilities at the Federal High Court. The Attorney General of the Federation at the time also set up virtual hearing facilities at Kuje Correctional Facility so that, around the country, we could start to take advantage of technology in our justice delivery because the pandemic brought everything to a grinding halt. And then shortly after that, the matter was in court, and what lawyers were trying to determine was the constitutionality of virtual hearings. Because then there was a section of the Constitution, and I'm glad Chief Ebo Suji mentioned it earlier, Section 36 of the Constitution provided that, especially in criminal cases, that hearings should be public. The public should be able to, and then there was argument back and forth. Gratefully, the Supreme Court held that, it was not unconstitutional to hold virtual hearings. So from my perspective, these are the sorts of challenges that we have to deal with and maybe overcome in order to be able to use technology to fast track or to facilitate justice delivery. And it's not just the court system, so that the information is not incomplete. It's not just the court system. Apart from the courts, every aspect of our justice delivery system is lagging behind when it comes to technology. If you look at the law enforcement agencies, a lot of things are still done physically and by hand, not enough records that you can access and process to be able to deliver justice at the speed and at the pace that is required for the 21st century. I think Uche is trying to tell me that my time is up.
Thank you very much. Thank you very much.
That's fine. I'm happy to go into details during the Q&A.
Thank you very much. Yes, I'll now invite Ms. Ojigo for your intervention.
Thank you very much. I'm really happy to be joining this conversation today. Without much ado, let me just start by saying that, and I also want to appreciate my co-panelists for really establishing the grounds in terms of what access to justice should be. I've been asked to speak on the issue of simplification and modernization of access to justice. But I wanted to just stress right now, after listening to those who have spoken ahead of me, that when we think of access to justice, we often tend to focus on the procedural, right? Especially if we are dealing with legal folks. But access to justice has both the substantive as well as the procedural elements. And it depends on how this is couched in order to, and how it's reflected to those who use the justice system. The other thing is, for us, it's about getting effective access to justice. So even if it's simplified, it's modernized, if it's not effective, and if it's not working to ensure that people's rights are protected within the system, people have equality in order to be able to approach the courts and get justice within the court system, for example, then the modernity that we seek has to be one that is enshrined and is entrenched on human rights standards, but particularly around non-discrimination and equality. So in terms of some of the things that have been shared already, the fact that cases take a very long time to be decided in our courts is a major factor. And the previous speaker has already spoken about about judges writing in longhand, and about how slowly we're getting to this point of getting justice to be speeded up in terms of responses to violations and issues that claimants have and even defendants have in terms of pursuing justice. But I also like to emphasize the point in terms of how those who use the system, especially victims, survivors, their family members, how they understand the justice system, how alienated they feel, the fact that they sometimes rarely understand what even all the numerous processes that we do as lawyers in the court is also a key if we're going to be able to make it more understandable and accessible for people who are non-lawyers and who are genuinely terrified to be facing a judge, facing people that are knowledgeable and have all the resources that they need in order to represent the needs of justice. And also the fact that oftentimes the courts, which are supposed to be the last hope for the common person, is also being seen as a tool of oppression, in the sense that if you the kind of legal advice and the kind of legal representation you get will determine the kind of justice that you also receive. And we've seen this happen a lot in criminal cases when people are charged for offenses and they cannot afford a lawyer and end up in jail, even to get their appeals done in time. And the quality of legal representation they get compared to someone who has the means, has the political clout and the status in order to have a huge amount of legal resources at their level. So in addressing the issue of simplification and modernization, it is also pertinent that we have a situation whereby it's not so much, yes, everybody approaching the court should be able to select a lawyer of their own choice, but where they cannot afford it, how do we evolve a legal aid system that is at the touch of a button, people can have access and see the profiles of a number of people that can represent them in cases. And then beyond technology, how do we ensure that we maintain a register of persons within the jurisdiction or the premises of the court that can be assessed without charge to those who need them? Because the final point will now be cost. The previous speaker has spoken about technology, and technology has been used as an example of how we can reduce the cost of litigating. But in a country like Nigeria, for example, where infrastructure, electricity, power supply is critical in terms of any technological onboarding you want. You also have the issue of economic, the fact that the resources that are allocated for this public service should be provided in a manner that does not exclude the generality of people who cannot afford alternative sources of power in order to access this technology when it is deployed. And I would also want to end my intervention around the classes of people engaging the justice system. So when you have women, children, or people who traditionally have been excluded from society in terms of opportunities, whatever methods we deploy have to definitely take into consideration gender responses, also responses in terms of the ages, the status of people engaging in it, to ensure that the system that is deployed does not discriminate and provides a level playing field as much as possible for everyone to get that substantive justice, as well as to be heard, not only in the court of law, but also loud and clear in society. Thank you very much. Over to you.
Thank you very much for all the intervention from panelists. And this has set the tone for the discussion segment. The first question I will be posing is about governance. Chief Idigbe, this question is for you. In an op-ed published by the cable and online news publication, Professor Chidi Anselm Odinkalu, in discussing the legacy of late Chief Justice of Nigeria, Aloysius Katsina Allo, said the following. Over 1 decade ago, it was clear that the Nigerian Judicial Council has constituted was unsustainable. It was equally clear that the ubiquitous role of the CJN in the complex web of judicial governance in Nigeria did not serve the person, the office, or the institutions of the judiciary well. Katsina Alu, and more recently, Tanko Muhammad, showed how a venal CJN could suborn the NJC. Court users and honest judges in Nigeria deserve better. In your view, Chief Idibe, is there something wrong with the current architecture of governance of Nigeria's justice system? You've hinted at that, but could you sort of build on that a bit? If so, what is wrong with the system and how can it be better positioned for the future? Thank you.
Thank you so much. You're right. I hinted on it already. Clearly, there are weaknesses in the governance structure. As I said, if you examine the structure of governance, you look at the NJC, you look at the FJSC, you would find that the intention of the Assure panel was laudable. They were trying to deal with the problem of interference from the executive arm at that time. And then they came up with this idea of centralization, having everything in the NJC, then having only the judges look after themselves, you know, and they thought in their wisdom that that was the best way to do it. But actually, Montesquieu's argument of checks and balance is unassailable. And having the absolute separation of power now gave rise to these other problems of cultism, promotion mentality, nepotism, etc. There's no accountability. I mean, the CGN is everything in the system, and you can see the pressure points. You then find the, not just only the federal government, even state governments, because they do the appointments and discipline of even state judges. And there are so many instances today where the NJC has recommended discipline of judges, of state judges, and the governors have refused to sign off. So they are technically not judges, but they are still judges because the sign-off has not occurred because there's a pushback at the state level, showing that the process has a challenge. The people don't feel completely involved. The public that we are serving, at the end of the day, justice delivery is for the public. The public is not involved at all in any way in all these processes. If you look at the reforms that occurred in the UK, it was driven by the Competition Commission saying that the public needed to be involved in the regulation of the legal profession. And so they had to drop all those ideas of lawyers ruling themselves, etc., and then brought in the public into the system. So there's need for reform, definitely, in terms of the composition. It's almost like an incestuous relationship that has been developed in terms of the governance. And we need to open it up, free it up, get the public more involved, have some sort of checks and balances. There's no member of the executive that is a member of the NJC. There is the Attorney General in the Federal Judicial Service Commission, but not in the NJC. And so you don't have that cross-pollination which is needed between the arms of government, and there's nothing that makes the CJN accountable. So essentially I agree, and it's a driver for reform. That's what I would say. Thank you.
Thank you very much. The next question I have is directed at you, Dr. Ebo Suji, and it's about funding and autonomy. On Friday, 15th July 2022, the National Industrial Court of Nigeria in Abuja ordered an increment in the salaries of the Chief Justice of Nigeria and other justices. The lawyer who filed the suit and secured the verdict was Senior Advocate of Nigeria, Chief Sebastian Horn, one of the panelists in the second panel. While many have hailed the decision as meaningful for securing the independence of the bench, there are so many critics who have argued that the suggested amount for increment is out of step with economic realities of many Nigerians. Others, such as the Attorney General of the Federation and the Minister of Justice, have argued that judges have no legal rights to have their own salaries reviewed upwards. Are you in agreement with the decision of the court? If so, can you succinctly tell us how we should respond to these criticisms of the judgment?
Thank you. That's a huge question. I'm going to try my best to deal with it. First of all, you had the first section of my my comments. I was going to speak about this when I agreed to come on this panel, but then a week or two later, the news broke that judgment had been rendered in a case I did not know was going on, and it was Chief Sebastian Hon that filed it. And I think that that development has to be one of the most significant developments in the modern history of administration of justice in Nigeria. And I don't know, you cited the arguments of the Attorney General. I don't know whether this came after the judgment or whether it was an argument he made in the stream of litigation. But let me put it this way. I mentioned the Canadian model. Now, I was surprised actually to hear that it was only Chief Sebastian Hon that engaged in that litigation. I've been reading now that some lawyers are now applauding the judgment. You know, in Canada, there's a system that resulted from the Supreme Court of Justice, Supreme Court of Canada's judgment of 1997 that I mentioned earlier. That system now required an effective, objective, and independent commission that looks at questions of judicial compensation every 4 years or so in a comprehensive way. And routinely, it is the Attorney General or the Minister of Justice that would oppose any huge increases in the judgment, in the salaries of judges. But routinely, it is the Canadian Bar Association that appears to argue that judicial salary and pensions must be increased. So it is the CBA that takes that charge, that leads that charge to protect judges in Canada. I'm surprised that the NBA is not doing that, and they should. It should be one of the mandates of the Nigerian Bar Association to take on this matter. I do believe, Uche, that the judgment of Madam Justice Obaseki Osage was entirely consistent with international standards. It is consistent, in my view, with Section 36(1) of the Nigerian Constitution. As I said, the persuasive authority for that would be the Canadian Supreme Court case that said that the right to meaningful pay and pension is a matter of constitutional right of citizens to an independent and impartial administration of justice. So I do think that the judgment is entirely correct. Now, briefly, you mentioned about people complaining that this may be out of whack. The problem there is this. That's not a new argument, but in the European Court of Justice actually took up that kind of case from out of Portugal in a 2018 judgment. Said, look, the judges of Tribunal de Contas, I think it was, had complained that the government of Portugal was involved in a drastic economic stabilization program that cut salaries. And the judges of that tribunal said, no, you cannot cut judicial salaries too. Remember that? The European Court said, look, no, that's not a violation of judicial independence because the salary was cut as a matter of economic stabilization across the board, where salaries of legislators, members of the executive, public servants, and judges were cut. So judges were not singled out in those systems. Therefore, there was no violation. Now, we have to ask ourselves, is that what's going on here? Or is it only the judges in Nigeria are the ones whose salaries are depleted when the pay and pension of members of the other arms of government have gone up and continue to go up? I think the answer to that question is clear. Thank you.
Thank you very much for your response. Mrs. Ojigo, I want to I've asked a follow-up question to your opening intervention on access to justice. So access to justice is a major issue for many Nigerians, as you hinted in your intervention. Now, this takes many forms, such as delays, costs, and complexity of the system, making it very difficult for the average Nigerian to benefit from the justice system. Many have thus resorted to self-help, as was hinted by some of our panelists, to fill the vacuum. What, in your view, will be involved in any attempt at simplifying and modernizing access to justice in Nigeria?
Thanks very much. Like you rightly noted, we're seeing evidence of self-help in many aspects. One horrifying one is around mob justice or mob violence, as has occurred in Nigeria across the country, from the burning of the young lady, Deborah, in the north, and then the young engineer in Lagos in the south. But what you find is that oftentimes those that are victims of this mob violence are people who were innocently caught in the process, or people whose information was shared in order to settle scores. That said, we've also seen clashes between communities who are facing wide range of insecurity across the country. So lots of reprisal attacks. And the question we always ask is, why are these happening? It's because people have lost confidence that the justice system would deliver justice, fairness to them, and that they're not going to be able to get any sort of closure in terms of what has happened to their loved ones or their current situation. And in the case of mob violence, we're seeing people venting their frustrations on people. Also with that understanding that the justice process is going to take forever. Simplifying the process to make it easier for people to understand, but also in languages and in places where it's not so threatening. A lot of people appreciate people in the entertainment industry because they have a way of turning things into music, into drama, into comedy, which people can relate with. So it means that for us in the legal sector, we need to also look at ways through which this can be bite-sized and absorbed by people very quickly. And then in the broader sense, to also make it easy for people to monitor these cases. It can be, we talked about length of cases, but one thing we haven't spoken about is the numerous adjournments that happen for whatever reasons. And people can understand it. We've given up, taking time off work, farm, whatever, to be in court. And then we come and then they say, oh, sorry, we've adjourned, or we can't attend to your case because something happened. It's so hard for the public to appreciate, the technicalities and the procedural processes that can elongate these matters. So we should also have cases that can be fast-tracked on the face of it. So that people know that if there's a case of theft of a certain amount, we know that within 3 months, there'll be a decision. Recently, during the state of emergency GBV declared by governors, and which was, advocated for by women's rights NGOs in Nigeria, many more states are now establishing SGBV courts. And why? Because they realize that the longer it takes to prosecute a case involving sexual and gender-based violence, rape in particular, the harder it is for survivors of these crimes to stay on course and not lose hope in the entire process. So choosing cases that can be fast-tracked, establishing specialized services, language, investing in language services so that people can come to court and say, okay, what are they talking about? And simplifying the language we use in court will go a long way in assuring people that yes, that this is working. And they will not become the defenders of the process. Because right now people don't understand what's going on. And so they use that to justify whatever reprisals or fallouts that occur as a result of delayed or perceived delays in justice.
Thank you very much for your response. Mrs. Alakija, you have spoken about the application of technology to the work of professionals and courts. This question builds on that. Criminal justice in Western jurisdictions have recently turned to the use of artificial intelligence to reduce justice-related delays, as research shows that AI could be a permanent part of the criminal justice ecosystem through the way it is used for investigative assistance, forensics, or helping law enforcement with prevention analytics and prediction tools for crime hotspots. Do you think there is any need for the justice sector in Nigeria to consider the use of such artificial intelligence application, especially when there are risks such as bias and discrimination, or how it may undermine some fundamental human rights principles such as privacy? I mean, AI is not yet a mature technology in many of its applications, but it keeps growing globally, and it seems it cannot be ignored. Should we be excited or worried? Is the use of artificial intelligence in criminal justice some form of an invasion, or is it a revolution?
Thank you very much for that question, or should I say those sets of questions, Prof. I think, look, my short answer is this. I think that yes, Nigeria should consider the use of AI. Do I think we should be doing that now? Maybe not, because I think that there are a few steps along the way that we need to get to before we can adopt the use of AI. In your question, you mentioned AI for analytics and forensics. For you to successfully use AI for analytics and forensics, you have to have the underlying infrastructure. You have to have the data. In advanced countries, I mean, when you watch movies, you see that, oh, there's a crime, they go and dust for fingerprints, then they check who it is. And, you know, the infrastructure that underlies all that is, first of all, you have a database of all the people in that country. You have their biodata. You have their pictures and their fingerprints. So that's the database you go to check the forensic evidence that you've gathered to see who it matches. So obviously, using AI to facilitate justice delivery in Nigeria is a good idea, but there are a few steps that that we need to take before we get to that point. So we need to, first of all, develop the infrastructure before we get to the point of deploying AI to our justice delivery system. Is it an invasion or a revolution? I think it's a revolution. And like every revolution, it will come with its challenges. So there will be issues in deploying AI to our justice delivery system. And I think, though, that the benefits will far outweigh the challenges. And you mentioned questions of discrimination and violation of fundamental rights like privacy. Look, profiling is something that law enforcement agents around the world use. Whether human beings will automatically profile, there's a way you look that we will decide that you have these kinds of tendencies. And that may impact how you interact with the law. If you are accused of a crime, it immediately throws you in a particular light unless we're able to establish otherwise. And that's the human element. I think that machines will have the same challenge. It may review or access data or predict certain patterns that, you know, would miss the mark at some point. And this is where we need to actively engage with the system and continue to refine it so that we don't send people to jail that don't belong in jail simply because the algorithm missed it. In terms of data privacy, again, like I said, I think that the benefits outweigh the challenges, but the key concerns around data privacy are usually how you collect that data, how long you store that data, what you use the data for, and the security of that data. Those are the primary concerns. If you're collecting data and building a data bank that would help deliver justice in any system, I do not reasonably expect, for instance, that if you have a database of all Nigerians situated somewhere in the headquarters of the Nigerian police force, I don't expect, for instance, that they will sell that data to commercial persons who are looking to send bulk SMS to advertise. I mean, those are the kinds of violations you're looking at when you talk about data privacy. Obviously, data security would be a big thing. So if we're deploying that kind of technology, we need to ensure that the systems are secure. And we're already halfway there. Whether we want to do it or not, we need that data for our day-to-day living. That's why we have NIN. This is why we have BVN. This is why NIMSI is collecting everybody's information and pressuring all the MNOs, the mobile network operators, to register all our SIM cards and connect it to our. This is the way that the whole world is going. All of us are going to come on board and put our data out there on some kind of technological platform, using that to then promote justice in our society. Cannot now become the one thing that we'll all say, oh no, we shouldn't do that because of data privacy. I think that we can do it within the bounds of the law and do it properly and use that to our advantage instead of against us.
Thank you very much for a very brilliant response. We are fast running out of time. We have a lot of questions from audience members, but unfortunately, it doesn't look like we have enough time to attend to the questions. But I think we can take one question. And this question seems to be directed at you, Mrs. Alakija. Okay. Does a judge making a record of proceedings not jeopardize the impartiality of the actual record? Should this not be the duty of another official who is impartial to all parties and judges? This could be resolved by having official court reporter or a technology that is under the care and control of that independent official. What do you think about this?
Well, the way it is currently, the judge takes the records of proceedings longhand, and then somebody transcribes it. It's more than one person that is involved in the process. And I think that if we deploy technology to do the same thing, it will be more than one person that will be deployed to deliver the process. But again, that would be the benefit of having audio and video recordings of proceedings. I mean, we will not be reinventing the wheel here. This is what we do for arbitration and mediation proceedings. You record them and then you transcribe, or sometimes you have speech to text directly. As we're having this webinar, if you look at the bottom of your screen, you will see that it is transcribing what we're saying. So it's happening real time. And so it is possible after this meeting to look at the transcript alongside the recording, whether it's the video or the audio, and compare, and then decide that these are the official transcripts for this hearing. If we do the same thing for the court system, I don't think the question of whether the proceedings have been, or the records have been tampered with or not, will arise. But in the meantime, what we do in practice is, if you have concerns about records of proceedings, after every hearing, you apply to the court for records of proceedings, so that while it is still fresh, you can look at it and, you know, already sort of identify if there are any issues. It is what it is. We make do with the system that we have. For now, that's what our law allows. And Mr. Idigbe said, and he did mention, you know, needing to revamp the legal framework. I think it is about time we stopped coloring outside of the lines and working with what the loopholes in the law are. And we should just, you know, update our laws and our practice directions or rules of procedure, so that we'll be able to, you know, improve our justice delivery. Thank you.
Thank you very much. Thank you so much to all my panelists. Sadly, that's all the time we have for the first panel discussion. I would like to thank our esteemed panelists. At this time, I would like to invite our audience members to stay for what promises to be an engaging conversation about operators of Nigeria's justice system, which will be hosted by my good friend, Mr. Leke Kainde, a Nigerian legal practitioner and partner at Kainde and Partners. We kindly ask for your patience as we bring in our second set of panelists. Please bear with us for a minute or so. Thank you.
Hello, everyone, and welcome to the session. My name is Leke Kende. I'm a partner at Kende and Partners, a multidisciplinary law firm based in Abuja, and I will be moderating this session titled Operators of the Justice System. Studies suggest that justice administration affects poverty and economic growth. Countries with efficient justice systems have lesser poverty rates and better economic indices than countries with inefficient justice systems. A more effective judiciary may also contribute to reducing violence and corruption by creating a deterrent effect on criminal acts and increasing citizens' trust in the quality of institutions. As a result, everyone ought to be interested in the administration of justice and the roles the operators of the justice system play. During the next hour, we shall be exploring the future of Nigeria's justice system from the point of view of operators of the justice system with some distinguished members of the legal profession in Nigeria. The first member of the panel is Chief Sebastian Horn. Chief Horn is a senior advocate of Nigeria and one of Nigeria's foremost constitutional lawyers. He is the principal partner of Law Shield Partners, a law firm in Nigeria with offices in Abuja, Port Harcourt, and Makurdi. The second panelist is Mr. Mazi Afa Musigwe. Mr. Mazi Afa Musigwe is a senior advocate of Nigeria and senior partner at Law Fort, a full-service law firm located in the heart of Nigeria's Federal Capital Territory. Mr. Afa Musigwe is also the former General Secretary of the Nigerian Bar Association. The third panelist is Mrs. Chioma Onyenucheya Uko, a lawyer, mediator, arbitrator, and gender rights advocate. She is the principal legal consultant at Zest Legal Consults, a law firm based in Abuja. Last but not least is Dr. Sirajo Yakubu. Dr. Sirajo Yakubu is a legal practitioner and academic. He is the principal partner at Sirajo Yakubu & Co. and is also the head of Department of Public and International Law at Now University, Abuja. A warm welcome to all the panelists. I'm glad you're here to join in this important discussion. Before going into the discussion segment, I shall invite each panelist to give a brief opening statement. At this point, I would like to invite Chief Sebastian Horn, Senior Advocate of Nigeria, for his opening statement.
You're welcome all. Thank you for this opportunity to discuss Nigeria's judiciary at an international level. As a matter of fact, our judiciary has come to stay. It has come a long way with challenges, with the ups and downs, and all whatnot. Now, discussions on a topic like this involve both a concentration of relevant constitutional provisions, the rules drafted by the National Judicial Council and the Federal Judicial Council. And then maybe as we go, depending on the time and the angles, issues are coming up, we shall also be trying to do maybe a comparative analysis or insight into some other, into what happens in other jurisdictions. So it is actually a good topic, and then taking place at a most auspicious time, because the Nigerian judiciary is undergoing some serious challenges, especially we're all witnesses to the fact that 14 Supreme Court justices wrote to the Chief Justice of Nigeria, a stinker, and that happened for the first time in the history of this country, forcing the Chief Justice of Nigeria to resign. And personally, I have been fighting for the improvements or for improvements in the lots of the justices and the judges of the Nigerian judiciary. And very recently, just about 1 week ago or thereabout, I secured a landmark judgment at the National Industrial Court to have their wages and emoluments upped or increased. So personally, I have been involved and I'm very glad to be here. I will just do my best within the time frame. Thank you.
Thank you, Chief Juan. May I invite Mr. Mazi Osigwe, Senior Advocate of Nigeria, for his opening statement.
Thank you so very much, Mr. Kennedy. I think the discussion concerning the Nigerian judiciary is one we'll never get tired of until the issues that are on the front burner are addressed. And such issues are issues of remuneration, autonomy of the judiciary, the issue of corruption, issue of judicial appointments and discipline of judicial officers, issue of succession in the judiciary, whether the need to continue to retain the current seniority situation in the judiciary where the most senior judge becomes the chief judge or the chief justice of Nigeria, or should the political leader, the president of a country or governor of a state be allowed to pick a person to be so appointed, since there is no such restriction on their power by the constitution. But we need to address some of these issues because, as we say here, the judiciary is the last hope of the common man. And if, as happened recently, 14 justices wrote a skin petition against Chief Justice, questioning his integrity, questioning his ability to do the work, and a whole lot of issues, then we need to address these issues. Otherwise, the public will lose the confidence in the ability of the courts to dispense justice. In any case, it's arguable whether they haven't lost confidence in the judiciary, because many people believe that if you have money, then you can have your way in the court. And if you don't have money, you may not be able to make justice in the court. And there are some of the views that most of our courts render judgments without rendering justice in cases before them. So I'm very glad to be part of this discussion. And I'm sure that I'll be able to share my thoughts and also learn from other panelists who would also have share their thoughts about the judiciary in Nigeria.
Thank you, Mr. Osigwe. May I invite Mrs. Chioma Oyenucheya Uko for her opening statement?
Thank you very much for the opportunity to be part of this august panel. And my respects to all the speakers who have spoken ahead of me. And I think for me, I want to say that it is important that in looking at the justice system, the whole spectrum of it, that we factor in the important roles played by the non-judicial staff. And this is important because while most of the conversation and most of the focus has been on the judicial officers as custodians who dispense justice in our courts, the support staff, who are the non-judicial officers, are integral to the dispensation of justice, because lapses that occur in the services they offer and in the support they give to the judicial officers are critical to effective delivery of justice. And of course, if we look at the whole spectrum of the judicial system, including the law enforcement and the corrections, of course, the courts being the focus for this conversation, you can tell that for the public, who are the consumers of the services that the courts render, and most of them do not get to interface with the judicial officers especially at first instance. And the impression that they get from the attitude and the service that the non-judicial officers deliver affects greatly the perception of the public of the judiciary, which in turn determines the confidence of the public in the judiciary or otherwise. So any conversation that happens without serious focus on the fate, the remuneration, the appointment, the training of non-judicial officers would be a conversation that is missing a critical link that impacts greatly on the outcome of the service sector delivery. So I think I'll rest it for here until the questions come, and then I'll take it further. Thank you very much.
Thank you, Chioma. May I invite Dr. Yakubu for his opening statement?
Yeah, thank you very much, Kendi. I'm invited, to speak in my opening remarks on the legal training and education in Nigeria. Legal training and education is very important. Very important is in the sense that a whole arm of government is actually manned by those who acquire legal education and their training. Only those who are lawyers can be found in the judiciary in an active role. The others who are there mainly are the supporting staff. So the importance of legal education and training cannot be overemphasized at this stage. If we have a whole arm of government with a lot of powers to decide on matters before it between parties, either as in a civil suit or in criminal matters, then you can see that legal education and training is very important. And because it is very important, then the way lawyers are trained should be looked into critically. At the moment, in most of our tertiary institutions, what we are having is the top-down directive approach in terms of teaching law students. Rather, because the top-down directive approach does not give room for interaction, does not give room for the students themselves to lead their learning process. There's need for to shift from this top-down directive approach to facilitation. Facilitation will allow the students to collaborate. They will allow the students to share knowledge. It will allow the students to explore, and then it will allow them to test the practical aspect of the law profession, because as you rightly know that law profession is practice-based. It is either a client coming to give you briefs and take down the briefs. They don't know, they only know that they have the problem, but you are the one to take them out of if it's a problem, you are the one to take them out of it. If it is a business that they want to do, you are the one to guide them properly. Even politics, law plays a greater role in determining what should be done and what needs to be done, and even after during election, when it comes to politics, in the pre-election matters and even post-election matters, a lot of input from lawyers are required. Then the whole justice system, the whole judiciary is involved. So training students who become lawyers and who populate the judiciary and who drive the justice system in Nigeria is very, very important. Then what else after becoming a lawyer? Then there's need for continuous education. Lifelong education is the answer here. A lawyer must continue to develop himself so that he will stay. He will keep himself abreast with the current laws and with the current happenings and practice the world over. Then the role of technology in education, in educating the students. With COVID-19 pandemic, we can see that a lot of institutions have embraced, virtual teaching in order to continue imparting knowledge to students. And in fact, with the advent of what we call now the metaverse, we should, it's highly probable that one day we will be sitting in our homes and we'll be conducting court sessions as if we are in real court while we are just not out there. So I think to wrap up, the future of the Nigerian justice system depends on the training of the quality. It depends on those who operate it, and of course, the standards of those who operate it depends on the quality of training they receive from the university up to the law school. With this, I think I'll stop, and I'll be glad to answer questions. Thank you.
Thank you, Dr. Yakubu. At this point, we shall be heading straight into the discussion segment. I would like to remind our audience that they can send in their questions, and if we have enough time at the end of the discussions, I will put some of those questions to the panelists. So let's dive in. Chief S.T. Hunt, this question is for you. Constitutionally, a lawyer who meets the requisite post-call experience and the requisite constitutional requirements can be appointed as a justice of the Court of Appeal of the Supreme Court. However, in recent years, the practice has always been to appoint only serving members of the bench to these positions. Now, several stakeholders have called for the widening of the recruitment pool to include academics as sir, in your opinion, are there any advantages of appointing practicing lawyers and academics as justices of the Court of Appeal and the Supreme Court? Or is the current model of recruiting judicial officers to these positions adequate?
Well, I will have a yes and no answer. The yes answer is that for practitioners, legal practitioners who have distinguished themselves, who have also met the constitutional threshold in terms of the number of years, they should be appointed. The clamor for this has been there for a very long time. And I believe that what any justice of the Court of Appeal can do, or of the Supreme Court can do, a good lawyer who has been practicing for between 12 and 15 years as per out to the Constitution, and who has been focused, well-focused, and also who has been very busy in diverse areas of the law, can practice, can become a justice of the Court of Appeal or the Supreme Court. Now, this clamor has been on for some time. This is not just the first time. And I think that we came very close to this thing happening in the last two appointments at the Supreme Court, but somehow it couldn't be. The body of senior advocates of Nigeria proposed some names, and one of the names is one of our foremost lawyers, Idigwe, Chief Idigwe, who was also in the first segment of this webinar. I wouldn't know why he wasn't considered, but this is a personality that has practiced law in all the strata of courts and who also has good experience and a lot of other lawyers in Nigeria who have such experience. It will add so much value to the bench. And what are the reasons for this? What are the additional reasons for this? If you don't do that, then the justices of the Supreme Court who are aiming, or the justices of the High Court, or the Customary Court of Appeal, or the Sharia Court of Appeal, who are aiming to be promoted to the next higher court, will be lackadaisical and will relax. They will just consider themselves that, well, after spending so number of years on the bench, they will look at my number of years and then promote me. In other words, it is now looked at as if it's a civil service issue, whereas we're supposed to have the best in our appellate system. So that is one advantage. The other advantage is that you are bringing fresh blood, so to speak, to mix with the people who are already there. So let's put it very hypothetically, you are bringing people from outside, quote and unquote, and then mixing them with people on the bench who are people who are inside. So you have that natural blend, the word outlook, then the inner circle outlook, if you like it that way. So they will blend and then they will give us the best. And then you also, the third reason is that you will also be bringing dynamism into the system. We have had experiences whereby, for instance, Honorable Justice Nnamani of blessed memory was elevated as Attorney General from outside, and he became one of the best jurists ever. Honorable Justice Oputa came straight from the High Court. He jumped to the Court of Appeal, and he also performed so well on the bench. Then, in rare cases, Professor Nicky Toby came from the academia, and he also did well. So that was why I said it was a yes and no answer, because people in the academia, I'm not being contemptuous of what they are doing, or I'm not denigrating what they are doing. But on a very serious note, very honest note as well, practice of the law is slightly different from what happens in the academia. So when you come on board, especially at the appellate level, and you have not had any experience as a practitioner, even some little nitty-gritty will worry you. You wouldn't know, for instance, to differentiate between a ground of law and a ground of fact, or mixed law and fact. You may not, you most likely will not also know the difference between filing, the time within which you are to file an interlocutory appeal or a substantive appeal. And then there are a lot of, because appellate processes, appellate proceedings in Nigeria, and I believe elsewhere, are highly technical. So it will take time. Before you take time to achieve excellence, you would have committed some blunders that will have a serious blight on the justice delivery system. So that is the only reason why I'm saying that people in the academia may not or should not be considered seriously as people who are in practice. So the advantages are there. And then when somebody is also changing environment, for instance, you are appointing someone from outside to go to the bench, the zeal to excel will be more than when he sees it as a right, as I'm here as the next most senior person. And then he will also be approaching it as somebody who is coming newly, seeking to impress, seeking to try to put in his best in terms of justice delivery. So the advantages are there, and we have always argued that for us to have the best, we should mix private legal practitioners who have excelled, who have at least shown themselves to be good practitioners, because everybody we know ourselves. And then because the process will be rigorous, the testing process will be rigorous. It could even involve voting at the level of body of senior advocates and the Nigerian Bar Association. And then the judges will also have an input. So with this, we will have a good blend and a good appellate system in place.
Thank you, Chief Estihon. That was a very interesting point of view. Even though I'm not sure Dr. Yakubu will agree with you that there's a disadvantage of appointing members from the academia. But anyway, we appreciate those contributions. Now, Dr. Yakubu, over to you. The campuses of the Nigerian Law School are facing a collapsing of infrastructure due to insufficient funding and ever-growing number of candidates. As a result, there have been calls to allow for the establishment of private law schools side by side with the Nigerian Law School, with a strengthened Council of Legal Education to set the examination for all aspiring members to the bar. Do you think the establishment of private law schools can improve the standard of legal education in Nigeria?
Thank you, Kende. I would like to engage Honorable Sebastian Holmes, but not here in private, on a discussion, not on a confrontational basis, on the need or on the merit of appointing academicians into the bench. But coming back to your question, actually, I think it is right, because I'm talking from experience. It is right now to allow private law schools. Why I say this is because of the number of students that are graduating every year from faculties of law in each and every, in almost all the universities. And I can tell you that law, like myself who is in a private university teaching, law actually is the most popular courses at Nile University. We have limited quota, but you get internal transfers from other faculties, because those who are not able to get admission to read law straight from 100 level, they will get admission to read into political science department, sociology, criminology, with the intention that after the first session, they transfer to the faculty of law. As I'm talking to you now, we have a backlog of students. Like last year, due to coronavirus, the law school was shut down for a complete year. But we at Nile, University of Nigeria, we continue teaching thanks to technology, like I highlighted in my opening remark. So we did not, after the first 2 weeks of confusion, we got a balance and started teaching using Teams, using Zoom, and other means. So because of that, we had two sets who are not able, who had to be combined together to send to law school. And by the time we were sending them to law school, we could only send 50 of them out of 100 plus. So you can see, and there are many other students who, especially in the public institutions, who are there waiting for the law school. Despite the fact that now that the government has approved more law schools, plus the one built by the River State government, thanks to the governor of River State, still the spaces, the space law school is not enough to accommodate all the students who have graduated. So based on this, I think it is very important for the government to consider. It will really, really help in absorbing the teeming number of law graduates who cannot get at the moment admission into law school because of because there is no facility to absorb them. If we look at the United States, United Kingdom, for example, law schools are even mostly private. I don't know any public law school in the United Kingdom. And the standard is not falling. In fact, the standard is one of the best standards. The standard of legal education in the United Kingdom is one of the best standards all over the world, because students come from Canada, from the United States, from New Zealand, from everywhere, come to the United Kingdom to study. So with proper, regulation from the Council of Legal Education, and especially with the suggestion that the Council of Legal Education should be the one that will be setting examination questions, just like WAEC and NECO is doing. I think we will still have a very high standard of legal training and education in Nigeria, even with the private law schools. And in fact, at the moment, there are already tutors at the campuses of the Nigerian Law School, private tutors, who are actually tutoring law students on how to pass the bar finals. And their success rate is almost 90%. So you see, this is already, there's already a litmus test, I can say, because some private individuals have constituted themselves either jointly or severally conducting tutorials, assisting the law school students to write and pass the above finals. Thank you.
Thank you, Dr. Yakubu. This next question is for Mr. Afam Osigwe, Senior Advocate of Nigeria. Now, Mr. Afam, continuing legal education is central to the development of a vibrant bar. However, many lawyers complain about the high costs of very good CLE programs. What incentive should be created and by whom to ensure that lawyers are able to access reasonably priced continuing legal education programs as they progress through their legal careers?
I think one of the incentives which we have at the moment is the MBA-driven continuing legal education, powered by the Institute of Continuing Legal Education, and also which you also have in the branches. Some of the continuing legal education programs are pricey, no doubt, but some that are also not so pricey as productive as those that are pricey. And it stands to reason too that if most of our lawyers do well in their private practice or in whatever organization they work, maybe, just maybe, they may be able to afford some of these things. But I think as part of his duty, which is the improvement of lawyers, and then law reforms and all that, and the MBA should do well to channel some of the money it gets from payment of practice fee to providing continuing legal education programs free of any charge to our members who may not be able to afford the expensive ones. Those who work in organizations that may be able to afford them or who can personally afford them may continue to go on with the ones they want. What is important is making continuing legal education taken much more seriously. If you look at the rules of professional conduct, it has provisions for minimum number of units every lawyer must, of legal education every lawyer must obtain in a year. Now, this provision of the rule has not quite been adhered to. Now, certificates are issued. We've not made it part of our licensing procedure that if you're unable to meet this minimum continuing professional development points in a year, your license will not be renewed. Until we make it implement the mandatory continuing professional development as contained in our rules of professional conduct, lawyers will still complain. It is natural for human beings to complain, especially here in Nigeria, about price of anything. For example, annual practice fee has remained at 4,000 for over a decade, and lawyers still complain that it's expensive, even though compared to the dollar, it's worth much less. And those lawyers will also have money to spend on some other things that may not improve their ability to practice their profession. But once it comes to making official payment or to self-improvement things, people would suddenly notice that the price is high. But bottom line is that institutions can provide some of these services and they can be better organized, and then the body should be licensed to provide them. And then if there's enough competition, maybe, just maybe, it will be able to drive down the price and make it much more affordable. But until then, MBA should continue to do the work is doing in providing continuing legal education free of any charge to lawyers, so that many more lawyers will be able to at least participate in them and improve themselves.
Just staying on the issue of continuing legal education, you talked about the fact that continuing legal education is contained in our rules of professional conduct. However, it has not been implemented as mandatory. Do you think it is time to make continuing legal education mandatory for lawyers in Nigeria?
It is, by law, it is already mandatory. That was what I said. We are not ensuring that there are consequences for those who fail to embark on continuing professional development and gain those points required by the rules annually. Because any lawyer can simply refuse to go for those training and continue to practice from day to day. Some have never improved themselves beyond their days in the University Faculty of Law or Nigerian Law School. They just keep practicing. They do not know about emerging areas of law. They do not know about changing legislations and all that. They just continue to practice. There's no effort made to develop themselves professionally. So that's why I said, if we should tie this to renewal of our practice license, and I believe they proposed the bill on the amendment bill on the Legal Practitioners Act of the Legal Practitioners Act, will be able to drive this because it has provision for licensing of a law office, renewal of license of practitioners. And this issue will be taken seriously because the legal profession should be able to showcase its best, should be able to showcase those, should be able to license to practice rather those who will be able to provide quality service to clients, who will be able to give top-notch advice to those who require advice from them, and so that the legal profession will be seen as those that, a legal practitioner will be seen as persons who are really prepared for the job. And it is only continued professional development or continued legal education that can do this. But when you have ill-prepared lawyers or lawyers whose knowledge is at best obsolete or many years behind, if you live with a large segment of people who give, we have a large segment of society that are dissatisfied with the quality of legal services they are getting. So I think it should be made, it should indeed sorry, a call keeps interrupting me.
All right, thank you, Mr. Osigwe, for your contributions. Now, moving over to you, Chioma. There has been a lot of public discussions on the inadequacy of the salaries of judicial officers. Chief Estinghorn just spoke about the case which he handled and the decision which was passed down. Do you think there has been a marginalization of non-judicial officers who are critical operators of the infrastructure of the justice system? Do you think that they should be included in the conversation as to increments of salaries?
Okay, thank you very much for that question. Straight away, my answer will be a yes, and an emphatic one. And I say that because just as the recruitment and the training of judicial and non-judicial officers are handled by the National Judicial Council, it goes to say that there is a realization that the effectiveness of the trained components within the judiciary is critical to effective delivery of justice. If it were just about the judicial officers having worthwhile remuneration, then maybe we'll be losing sight of the role of the non-judicial staff in the dispensation of justice. Oftentimes, the court users, the litigants and the rest of the people, the rest of the public who come in contact with the court, come in contact with the non-judicial staff at the first instance. And it is only after things develop to the point of hearing and the rest of it that they now transcend to meeting with the judicial officers. And since they are the people who interface mostly with the public, it is important that their commitment to duty, their sense of dedication to their job is encouraged. And there is no way that can be optimally encouraged if we do not take into cognizance the role of, you know, proper remuneration as a means of encouragement and as a means of motivating performance and output. Most of the things we hear about how the judiciary is corrupt and what have you do not stem from the activities of our, you know, judges and our justices and even our magistrates. They are mostly stem from the impression of the public from interacting with non-judicial officers. You see things like maybe extortion from the public, maybe because we do not have a coordinated way of, you know, documenting and even appraising costs in service delivery. So oftentimes you see many of them extort people even for little things like service of processes, and then, you know, compilation of records of proceedings and all of those other things. So it is critical that we pay attention to see that our non-judicial officers are well remunerated, particularly in a country such as ours, where inflation keeps rising by the day. If we look at the cost of living now, it will be almost ridiculous to expect that some of the you know, advised rates, like for example, for service of processes, maybe to designated locations and distances can continue. There is no way that will continue. So you see that many times, many of them look for ways to make ends meet. There was that disclosure by the Chief Justice of Bauchi State recently, who complained, she raised the alarm that non-judicial staff within the Bauchi State Judiciary were you know, getting engaged in corrupt practices, and to the tune of, I think, about 11.5 billion naira or something of the sort, you know, forging forms, forging letterheads, forging all sorts of things to circumvent the process and the institution, and then, you know, make monies from the side. So we need to deliberately refocus, not just, I mean, it's most commendable, the action taken by the learned senior advocate of Nigeria, Sebastian Horn, in ensuring that the fate of our judicial officers are, you know, better served. But that needs to extend to the non-judicial officers, because really their roles are critical. If you remember, just very recently, they caused a paralysis, as it were, of the justice system for over 2 months by the strikes they embarked on in 2021. And that tells you the enormity of the powers they hold. Well, whether we want to recognize it as such or not, this is a people who can determine whether or not the rest of the system works. And if we realize that, then we must deliberately pay attention to ensure that their needs are met and that they are given optimum support to deliver the roles they are assigned to deliver.
Thank you, Chioma. Quickly, because we're running out of time, I'll just ask one more question for Chief Horn. So are you there?
Yeah, I'm here.
Okay, so quickly, in 5 minutes, sir. Federal judges are appointed a quota system called the federal character, so that all regions are represented at the federal level. In your opinion, do you think the observance of the quota system in the recruitment of judicial officers affects the overall judges be based solely on merit, or should the current quota system continue to be factored in such decisions?
I will support wholeheartedly the quota system, that it should continue. Now, gone are the days when maybe one particular region in Nigeria held the S, we have a situation whereby all regions of Nigeria now, as far as the legal profession is concerned, have very competent people, either on the bench or at the bar, to fill in these quotas. So Nigeria is a multi-dimensional country, multi-ethnic, multicultural. So there's no way we can do away with the quota system. The Court of Appeal and the Supreme Court of Nigeria also deal with issues of Sharia law and customary law. And then we have a good number of people in northern Nigeria who are experts in Sharia law, and a good number of them are also experts in customary law. Now, if we say that appointments to the Supreme Court and the Court of Appeal should be limited to particular zones, those two aspects of the law will suffer. And I also say that quota system is established in the Constitution. Except if we are going to restructure fundamentally and do away with quota system in all aspects of our life, the issue of maintaining quota system in the judiciary remains sacrosanct. It should be there. And now look at a situation whereby we're talking of regions, geographical spread. We're not talking of state by state. We have 6 geopolitical zones in Nigeria. So if, for instance, in the north central zone that I come from, somebody from Benue State, which is my state, is not as good, you can go to Nasarawa State or Kogi or Kwara State and pick somebody from there whom you think is good. The same thing happens if you go to the northeast or the northwest or to the southwest or southeast or south-south. So we don't have, in Nigeria now, we have good legal practitioners in all the zones. We have good judicial officers in all the zones. We have good academia in all the zones. So there's no way anybody will begin to tell me that we should abolish quota system and then go for the best. Where are the best? The best are in all the zones. So, and they will keep coming because everybody is involved. Everybody wants to excel. Now, let me give you an example. I'm a member of the Legal Practitioners Privileges Committee, the body that appoints and disciplines senior advocates of Nigeria. Now, we just finished one inspection of law firms. And this is my 4th year, my 2nd term, which will expire this year. In all of my 4 years, people of all zones have excelled because we do chambers inspection. There was a time I traveled to Kano, I traveled to KB, what I saw, I was pleasantly surprised. And then we also conduct interviews of applicants. Come and see how people from all zones are excelling. And then some people from the zones who think you excel, some of them may not be as good. And again, quota system is not just the criteria. If you look at Rule 3 of the NJSC procedural rules for appointment of judges, Rule 3.6, paragraph 6.4, they said, in carrying out the provisional short listing exercise, the chairman of the Judicial Service Commission or committee shall take into consideration as much as possible. Then they started listing. If you go up to 4, federal character or geographical spread, and where necessary and possible, without compromising the independence of the judiciary or allowing politics to permeate or influence the appointment. So there's a balancing provision. It's not just that you just go there and pick anybody. You have to balance it, and even in the balancing, you do another balancing to make sure that politics and improper appointments are not appointees are not put into our judicial on our judicial benches. So I go for quota system any day, any time. Now, if you do a comparative analysis, a lot of such criticisms I have with me here the NJSC rules. They are more comprehensive than what we even have in the UK. And for God's sake, go to America. It is even based on politics. When they want to appoint justices to the Supreme Court, they talk of the Democrats and the Republicans openly. And he's there, even within the states. So, but here we have standard rules that are guiding us. And we're still, those things, quota system, rather than divide us, brings us together. Because everybody has a sense of belonging. And in every zone, and I dare say, in almost all the states, we have competent hands. And they have been delivering. Me, I'm a researcher, I write books, as maybe most of the practitioners here will know. And I quote judges in extenso. I quote their findings, I quote their judgments. There's no limit to knowledge. There's no limit to knowledge based on ethnicity or geographical location. I can assure you of that. We have had fine justices on the Court of Appeal bench, on the Supreme Court bench, even as we speak. I don't want to mention names because these records, they are still sitting. If they were not still sitting, I would have mentioned people like Mahmoud Muhammad, the former Chief Justice of Nigeria, who is from Taraba. Very, very articulate justice of the Supreme Court. He ended up as the Chief Justice, and then Kasina Alu. These are people from the north, and then we don't want to mention people from the advantaged geopolitical zones. They are already good, but we have also had good ones before, and we will continue to have, even now we have. So quota system brings us together, encourages everybody, and it binds us, it builds the federation. This is not a loose federation. It's a watertight federation. Thank you.
Thank you, sir. Unfortunately, we've run out of time, so we have to bring this session to an end. I would like to thank all the panelists for their time and insightful contributions. I would also like to thank our audience for tuning in and joining us. At this point, I will be handing over to Professor Uche for his closing remarks. Thank you, everyone.
Thank you. Thank you very much to all our panelists for a very robust discussion. Thank you, my good friend Kayode, for facilitating such an insightful discussion. And a tremendous thanks to everyone else who has attended this panel discussion for being a part of our webinar today. We're grateful that you joined us from different time zones to share your wealth of knowledge and expertise with our audience. I would like to also thank the team at the Lincoln Alexander School of Law that has made this possible in terms of the technical support. If you enjoyed today's webinar, please check out our website at the Lincoln Alexander School of Law and follow us on Twitter for news and updates about future events. Thank you for joining us, and we hope to see you again very soon. Thank you.
Thank you. Bye-bye.
Bye-bye. Thank you.
Thank you very much.
Thank you.